compensation where penalty is stipulated for. This is not Article 74, Section 74 of the Indian Contract Act. And we are dealing with a contract where the contract itself has a provision stipulating the quantum of penalty payable in case of breach. The contract itself takes care of the breach. Let's see the provision. Where a contract has been broken and if a sum is named in the contract itself as the amount to be paid in case of such breach, which means an amount is already specified in the contract which will become payable from the party which breaches to the suffering party. Or another situation is if the contract contains other stipulation by way of penalty, if not an amount but a stipulation, then the party complaining of breach, which means the party which suffers the breach, is entitled as a right to receive from the party who has broken the contract how much compensation? Reasonable compensation, not exceeding the amount so named or the penalty is stipulated. So it is not the amount which is named in the contract which will become payable. The amount will be decided by the court and it will only be a reasonable compensation. The maximum is the amount which is specified in the contract. And in this case, it does not matter whether actual damage or loss was caused or not. Now, please compare it with Section 73 very carefully and see the difference between one very important fact, that of actual damage or loss. Whereas in Section 73, actual damage or loss must be there. In this case, it is not a requirement. So even if there is no actual damage or loss, compensation can be awarded under Section 74, and Section 74 becomes applicable only in respect of those contracts where a sum is already named in the contract which will become payable in case of breach of this contract, or if there is some other penalty, other stipulation which will act as penalty to prevent breach of contract.